All right, we're going to go ahead and get started. And this webinar is being recorded and will be available to folks who registered but weren't able to attend. But welcome, everyone. I'm Elizabeth Vaughn with Community Alliance with Family Farmers. And I'll allow Ken to introduce himself in a minute, our speaker. But just wanted to welcome folks, let you know that CAFF was interested in hosting this webinar because of our Small Farm Innovation Challenge that we host every year. And I encourage you to learn more about that challenge if you haven't had a chance to learn about it. But often we get farmers who are asking us for advice or ideas on how to protect their intellectual property. We also get farmers sometimes asking about marketing support, maybe a brand or they're something that they've created. They want to make sure people don't copy and take. So we're excited to bring this resource to you because we learned that our federal office has a lot of great resources for the community that are available to you. And so we just want to make sure you're aware of them. So we are thrilled to welcome Ken, and I'll be helping to moderate the Q&A as well. So as questions come up, please feel free to post those in the chat or in the Q&A, and we'll hopefully have time to address those. So Ken, why don't we get your screen shared and then I'll let you take it from here.
All right, let me try to screen share. And my slide. Oh, I guess it already is. There we go, I believe.
Yeah, looks
One
good.
second, I need to set something else up. I apologize. There we go. All right. Hello, everyone. I'm Ken Takeda. I'm a regional outreach officer here in the Western Regional Office of the United States Patent and Trademark Office. Yes, it's a mouthful. I'm actually located in our Western Regional Office, which is right in San Jose, California. If you kind of see the virtual background behind me, San Jose, we, as the Western region, we serve 7 states in the Western region, including Alaska and Hawaii. You might also notice we do have other regional offices throughout the country, and then our headquarters is out in Alexandria, Virginia, which is just outside of Washington, D.C. And again, I'll try to answer as many questions as possible, but I do have a somewhat lengthy slide deck. For the most part, it's going to cover intellectual property, kind of the basics level, and then I'll go into some of the resources that are available from the USPTO. They are free resources anyone can use. And then we'll hopefully cover quite a few questions, Q&As. But again, as Elizabeth has mentioned, please feel free to put questions into the chat. Please do not include too much personal information, especially if you have an invention. You don't want to disclose your entire invention to the public. So I might get into a little bit of that during the presentation itself. With that said, let's get started. And here we go. Intellectual Property 101. Just a general notice, I'm not an attorney. I cannot provide legal advice, um, as well as I cannot provide direct business strategy advice. So just keep that in mind. You might have very specific questions on what you should do as a business owner about your intellectual property. I can provide considerations or factors that you should consider, but I can't give you direct advice on how you should do things. Okay. Let's so basically intellectual property is rooted in our US Constitution. In Article 1, Section 8, Clause 8, you'll notice this phrase to promote the progress of science and useful arts by securing limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, this clause actually addresses two forms of intellectual property. That's copyrights and patents. So if you just kind of weed out a couple of these words, useful arts, limited times, inventors, exclusive rights, and discoveries, that's actually addressing our patent system. Back then, useful arts were considered technologies, different types of technologies, but it's providing limited time rights to inventors on their discoveries. And then the other half for this phrase is science, limited times to authors, exclusive rights to writings. That's addressing copyrights. And back then, um, writings were considered the way of um, promoting or distributing knowledge and scientific facts. So that's why it's considered science in this form. Now, trademarks, interesting enough, is addressed in another part of the Constitution um, that addresses commerce. And I'll explain why trademarks is associated to commerce specifically. So the U.S. Patent and Trademark Office, USPTO for short, we are a government agency, federal agency within the Department of Commerce. We're basically a fee-funded agency. We don't use taxpayer money. All of our budget, annual budget, comes from people applying for patents and trademarks, and the fees that they, submit for us to examine them and issue them if we find them worthy. Now, our agency is somewhat large. We're about 14,000 employees all around the country. The vast majority of our employees are patent examiners. So if you think about patents and patent applications, that's what they examine. Um, in fact, just last fiscal year, our federal fiscal year starts in October, ends in September. We received over 660,000 patent applications from all over the world, all trying to get a US patent. During that same time, we issued about 360,000 patents. Now, those aren't one to one. Just keep that in mind. It actually takes 2 to 3 years sometimes to actually receive a patent application, for us to examine it, to discuss with the applicant if there's any changes needed, back and forth correspondence and such. And like I said, it might take 2 to 3 years to actually get that patent application granted, or it might become abandoned. Um, so those patents that were issued in fiscal year 2024 were probably submitted as applications 2 to 3 years before that. And then trademarks, we receive over 700,000 trademark applications a year. And about half of those are become granted. So it's a large, we get a lot of volume every fiscal year. That's why we have quite a large number of patent examiners and a large number of trademark examining attorneys. Um, there's also a little picture down there on the bottom of our headquarters down in Alexandria, Virginia, just outside of Washington, D.C. So what exactly is intellectual property? So much like real property or physical property, like you see on the left here, real property, it's something you can touch or whatnot. It's an asset, right? It's something that you own where you could lend it out to someone, you can, own it, you can rent it out, whatever. It's property. Even with the fence around it, it kind of marks your boundaries of your property, right? That white fence. Now, intellectual property, same idea, except it's intangible. It's um, property from your intellect, right? It's an idea. It's a creation from your mind. That's why it's called intellectual property. It still could be an asset. It still could be valuable. And and similarly to the white picket fence here, intellectual property has its own legal fence. That basically that's what the intellectual property defines. What is your idea that you try to exclude others from it? And so that's what we're going to be discussing, intellectual property. And in the United States, we recognize four main types of intellectual property. Patents, as you can see here, is probably what you can imagine. There are protections on new inventive ideas. Um, they can be other things, and we'll describe that a little bit later in the presentation. But for the most part, they're inventions. They have to be new, which is a one big caveat here. So they've never been done anywhere else in the world. Um, then we have trademarks. Trademarks are basically source indicators of a good and service in commerce. Now, you could already see some logos and then you recognize them instantly as trademarks. Copyrights are protections of creative works. So think about music and books and maybe movies. Those are creative expressions. Trade secrets is just like what it sounds like. It's a secret. And it has commercial value because it is kept a secret. And we'll describe all of these a little bit later. Oh, one main thing. So I mentioned how, these are the four main types of intellectual property that the US recognizes. Why do I say that? Because all intellectual property is territorial. So if you get a US patent, for instance, you have protections in the United States and its territories. However, it's only good in the United States. It's a US patent. Now, if you say, oh, I want a patent protection in Germany, well, you're going to have to get a German patent. If you want patent protection in Japan, you're going to have to get a Japanese patent. All intellectual property is territorial, with the sense that every country has its own laws and regulations on the intellectual property that they recognize and enforce, protect. So many of the, say, patent laws, especially with the larger countries, we have very similar laws to some of the major countries, and we can do cooperatives and things of that nature. But there's no such thing as a global patent. There's no such thing as a global trademark, and that's a very valuable thing to know. And that could be a very big business decision on for you if, as a maybe a business owner, if I want patent protection in every country I can get patents, well, that's going to cost you a lot of money because every one of those countries is going to require an examination fee. So keep that in mind. Um, let's continue. So some of the benefits of intellectual property, and you probably know some of these already, especially if you're like a Shark Tank watcher, a show watcher. Um, they can be assets. They are a form of property, right? If you ever look at the actual patent, an issued patent, it looks like a legalized document, and that's what exactly what it is. It's a legal document for property. Um, so as any asset, and I kind of mentioned this before, you can sell it, you can lend it out to someone, you can lease it, you can impose your rights using it, things of that nature. Some of the other benefits of intellectual property, you could protect your investments, right? Say a pharmaceutical company spends billions of dollars researching and developing a new cure for cancer or some other disease or something, right? Now, if they get a patent on that new drug, they potentially have the exclusive rights to it for a limited time. And during that limited time, they hope to recoup all that investment money they initially poured into it, into research and development, to actually recoup the money and then also maybe make enough profit to research and develop something else. Just like if you spent years of time working on a best-selling novel, well, you're going to want to protect from others actually copying your novel and distributing it without your authorization. So that's a copyright right there. You want to get a copyright. Some of the other things, you can gain entry to a market, just like a patent might be able to do that, right? Um, exclude others from the market as well. So a little bit um, non-obvious, but so even when you submit a patent application, any type of patent application, you can start saying patent pending. Sometimes patents, because there is a legal fence, you could actually carve out new markets for you with that. new innovation in the patent. And also branding, of course, trademarks now. Now, trademarks of I briefly mentioned as source indicators of a good service, but those same source indicators build your reputation of your company or your brand, right? And we can discuss that a little bit further as well. And of course, you can attract investors and partners, just like I mentioned. Shark Tank kind of uses that kind of concept. Now, it's very important to recognize that it's the onus of the owner of the intellectual property, right, to actually enforce their own intellectual property. There's no government agency that will automatically do that. So if you receive a US patent from our agency, it's great. You have a patent, US patent. What do you do with it? How do you enforce it if someone's infringing on it? Well, you can use it to go to court. You can, send cease and desist letters. You could, if they're already using your invention and you have a patent on it, maybe you could offer to sell your patent to them, or maybe you can license it to them. Think different things like that. But um, keep in mind, though, it's really up to the owner of the IP rights to actually enforce it. And as a business owner, well, how much money is that going to cost you to enforce your own intellectual property? That's a huge consideration, right? So I've already kind of put out there, like, if you want to get say, a patent in Germany, you're going to have to pay for those fees. Now, if you want to enforce your German patent in Germany, that's potentially going to cost you resources. So let's go through these one by one. And I'm going in the reverse order to the table that I kind of described. And trade secrets is probably the easiest one to describe because it really is just a secret. Um, Trade secrets are basically anything that's could be commercially valuable as long as it's kept secret. So it doesn't even have to be all that fancy or inventive. It could be as simple as a client list, right? But it's still important to you and your company, and you don't want your competitors getting that. So you keep it a secret, right? Um, Now, keep in mind you do not register trade secrets with any government agency, otherwise they wouldn't be secrets. Um, and it's up to you as the owner of the trade secret to really to make sure it doesn't become disclosed. Um, you might have to use like NDAs, non-disclosure agreements with your employees or with your investors that you're pitching your ideas to, or something of that nature. You have to take steps to keep these things a secret. With that said, potentially you could keep that secret forever. However, going to the next slide, I think. So the next slide. Oh, not quite the next slide, but there are many ways of losing a trade secret. If it's something like a simple device, it could easily be reverse engineered. Maybe an employee who knew of the secret leaves your company and joins another company. That could be another loss of your secret. Um, Maybe you just forgot to lock your safe one day. But also, you never know. It could be independently developed by someone else. So keep that in mind. So once the secret's out, it's out, right? That's the danger of keeping something a trade secret. And some of the kind of the very famous trade secrets examples, well, KFC's blend of 11 herbs and spices, or Google's core search algorithm are examples of tightly held trade secrets. Coca-Cola's formula, right? The recipe to Coca-Cola, that's a closely held trade secret. And they've held that for years, decades, right? That's huge. Other examples, formulas, um, and I already mentioned recipes and such, like KFC's herbs and blend of 11 herbs and spices in Coca-Cola's recipe. Recipes are really hard to actually reverse engineer, right? You might know the ingredients, but not maybe not the proportions and not the method of how they put them all together. Um, and I already mentioned client lists. They don't have to be all that, elaborate type of information. It could be something as simple as your client list that you don't want your competitors have. Let's continue on to, well, actually, at this point, any questions so far, just in case?
I haven't seen anything come through the chat yet, so and if folks want to
Okay,
add anything in the chat or you're welcome to come off mute as well, but we can also take things through chat to make sure we have them for the end at least.
I'm sorry. I realize this is on my screen. Is everyone seeing this bar?
The copyrights slide is up. I don't think we see the bar that you're seeing.
Okay, good,
It's
good, good.
probably just the Zoom bar, which is not visible to others. Yeah.
That's exactly what it is. All right, I wasn't sure. Thank you. All right, copyrights. So, copyrights are fun because they are creative expressions written down or put on a fixed medium. Now, looking at the bold words here, original and fixed. I want to emphasize these 2 points. Um, Original works, that's pretty obvious. They have to be fairly new original works, right? But they have to be fixed on a medium, on something, and actually for it to be a copyright. So I'll give you an example. Easy one is you write a great story, you end up writing it on, typing it on paper like the picture. You might write it on Word document or some other computer app. That's those are fixed mediums. Paper, the computer. Um, Maybe you wrote it on a stone tablet back in the day. That's a fixed medium. Now, if you wrote a new song and you're just playing it on your guitar, maybe, and no one's recording it, or you don't write it on a score down or anything, you're just playing it and just goes off into the air. That is not a copyright because it's not fixed on anything. Now, if someone went and recorded it, that could be a copyright. If you wrote it down on a piece of paper, the notes, that is a copyright. And I could tell you right now, everyone that's in this session has copyrights because copyrights are created as soon as you write down original work on a fixed medium. So back in middle school, when you had to write a poem for class, that's a copyright, as long as it was original, right? If you had to write a story for a reading class or something, writing class, if you did some AV classes and did some movies and things of that nature, that's all. If you even used your mobile phone and did a selfie, took a selfie, that's a copyright. Keep that in mind. Now, other forms of copyrights. Well, music, books, movies, artwork, photos, television shows, sculptures. I could read the list, of course. There's other things. It has to be artistic forms. Now, the interesting thing is, um, it's not the idea that's the copyright. It's the expression. It's your expression of your idea. There's probably thousands of books and thousands of movies with the same type of story, but it's the way that they made it unique, the story unique. That's that's the expression, right? So I'm trying to think of a good example and I can't think of one. I apologize, but it's really not the idea in itself. It's how you wrote it down, how you put it on a fixed medium. That's the copyright. There might be a hundred like stories, the common story of, say, um, a father and son going fishing somewhere and getting into an adventure, or some other similar scenarios. But it's how you wrote it down on a piece of paper or whatever the fixed medium. That's the expression of the idea that's protected, not the idea. Okay, hopefully that's clear. I probably muddled it up quite a bit. Um, Also, copyrights have a very unusual term of protection. So they generally the author's life and 70 years after the author's death. That's the main form of protection. Now, if it's a company or a business that um, creates a copyright from a work of hire, then it could be 95 years from the date of publication or 120 years from creation, which whatever expires first. I know that's a little confusing, but think about Walt Disney first publishing Steamboat Willie, right? The first version of Mickey Mouse, that cartoon. Well, that went under the 95 years from the date of publication term, and it was just became public domain last year. So in 2024, January 1, 2024, Steamboat Willie basically became public domain. And you might soon see different versions of Steamboat Willie. Other people are just creating movies or whatever. I don't know how what they're going to do with it. But you might have already seen some variations of Winnie the Pooh because Winnie the Pooh expired 2 years before that. I think Tigger actually is still under copyright protection because he wasn't introduced until later. But just keep that in mind. All right, let's continue. Sorry, I keep looking over here because that's where my little video is. I apologize. Um, some things that are not protected under copyrights, and I mentioned this already. If it's not fixed, it's not protected. Some simple content, things that don't really have any type of originality to it, titles, names, symbols, familiar symbols, that is. Very short phrases. And again, I mentioned ideas themselves are not copyrighted. It's how you express them on the tangible or fixed medium. And of course, anything I do as a US government employee is not copyrighted. Now, I mentioned this before that all of us are copyright owners. It's automatic. It's automatic. Now, you can get more rights if you actually register your copyright with the US Copyright Office. You can get more rights doing that because it's automatic under common law. But if you want federal rights, strong federal rights to your copyrights, then you should consider registering with the US Copyright Office. It's not the USPTO, US Patent and Trademark Office. We actually have two different offices. Some countries actually have combined them into one office, but at the United States, it's separate. And why would you want to register your copyright? As I mentioned, you get stronger federal rights, one of which is that you could actually go to federal court and sue someone instead of wherever the locality is in like a state or something court. And again, go to the US Copyright Office to do those registrations. They're fairly cheap. I don't recall what they are right now, but okay. Trademarks. Now we're finally in the wheelhouse of the US Patent and Trademark Office. Um, what is a trademark? Trademark is basically any source indicator of a good and service in commerce. So if you look on the diagram on the left, you probably see easily this big apple silhouette. you know exactly what company that is, right? You generally know what types of products and services they provide because that's such a strong trademark. Even if the McDonald's wasn't listed there and all you saw was golden arches, you know exactly what company that is, what they sell, right? You don't have to recognize the words on it. It doesn't even need the McDonald's on it. That's a strong trademark. And that's what these things do. They basically are source identifiers of goods and services and something you can build your reputation on as a company, right? Like McDonald's, you might not love it, you might not hate it, but you have a definitely opinion on McDonald's in that brand, right? Same thing with Apple or Macy's that's here, or I think that's a Girl Scout symbol, right? Or these are somewhat old trademarks, but we'll get into more recent ones soon. Also, an important thing is the TM, SM, and R circle. Just like copyrights, you can get common law trademarks as soon as you start using a source indicator in commerce. In that case, you can start using TM or an SM if you want. It's optional. TM means trademarks, SM means service marks. They're basically both the same thing. Service marks generally is just the source of a service, right? So instead of selling a product, specific product, you're selling a service. So think about an accounting firm. They're selling their accounting services, not necessarily a product, right? Um, just like a plumbing um, um, service, right? A plumber isn't selling specifically a product. A plumber is selling their service. So that's just a slight difference. Overall, you could use TM for both of them. It's kind of generally understood as both trademarks. And again, you can use this whenever you start using a trademark uh, in commerce. You don't have to register with us at this point. Now, if you do register your trademark with the US Patent and Trademark Office, you can start using the R circle. That means registered. Okay. Oh, all of a sudden I'm drawing lines. Okay. Sorry about that. I didn't realize that. um, why are trademarks important? This is kind of a fun little exercise. If I want to go down the street and get my favorite flavor and brand of toothpaste at the store down the street, I go into the store and all of a sudden they just have tubes of this in an aisle. Maybe the aisle says toothpaste. Well, do I just pick up anything? No. Would you pick up anything? No. Who knows what this is? I don't even know if it's toothpaste. I don't know what brand it is. If it's my favorite brand, I don't even know what flavor it is. Right? What if it's like hemorrhoid cream? Ugh. Kind of the same idea. Maybe it already says beverage on it, but I want a Coca-Cola. I've been dying for a Coca-Cola for a day. It's how do I know what this is? You don't. So that's the power of a trademark. Again, identify the source of a good and service. Common law trademarks, I kind of already mentioned these. Again, you could start using SMTM as soon as you start using a trademark in commerce. You don't have to register it with the USPTO. Again, these are optional symbols. Now, you do have limited rights on these common law trademarks. They're usually very limited in the geographic area that you're doing commerce in. And if you go interstate across state boundaries, well, you don't really have any rights across state boundaries unless you have another source of commerce in that other state. So these are some of the considerations you want to consider, or sorry about that. So these are some of the factors that you want to consider, especially if you're doing interstate commerce, is that a federal registered trademark at the USPTO covers the entire United States, not just a small geographic area. So some of the advantages, um, you can go to federal court, just like a copyright, registered copyright at the U.S. Copyright Office. You can use the R symbol, or R circle symbol. Um, and for both copyrights and trademarks, you could actually register them with U.S. Customs and Border Protection, and they can help seize imports or counterfeit imports coming into the country. Other common examples of trademarks, you already know what these are, right? Starbucks, just the word, that's a trademark. The symbol with the mermaid, another trademark. Nike, the word, trademark. Stylized check mark or swoosh, trademark. Target, Target, right? You know exactly what those companies are and roughly what they sell. That's the power of a trademark. Other examples of trademarks, words and slogans, just do it, for instance, right? Nike. Symbols, designs, anything that could be a source indicator, even smells, colors, and sounds. In this example here, I really wish I could take off this little lines that I've been drawing. But Pillsbury Doughboy has a very recognizable trademark when you push in his tummy. He giggles, right? That's a sound trademark. Think about the Aflac insurance duck. Every time he says Aflac, that's a sound trademark. Um, Play-Doh is the very first scent or smell trademark. You recognize, if you've ever played with Play-Doh as a kid, you immediately recognize that smell wherever you go. You don't even have to see the can, right? If you suspect Play-Doh, like in the seats of your couch, as soon as you start smelling that sound, that smell, right? That is a scent trademark. And colors can be trademarks. Um, just like Corning's fiberglass, pink fiberglass insulation, right? There's no reason insulation needs to be pink. It's just a trademark. Now, it doesn't mean that Corning owns the color pink. It just means that other construction products for insulation can't be the color pink. Just like brown for the color UPS, United Parcel Service. No other delivery company can use the color brown as their trademark. They don't own the color brown. Some other things to consider. Um, Maybe you registered a domain name with some company. That's not necessarily a trademark. It can be. You can make it a trademark if you start selling in commerce using that domain name, but these are different entities. Similarly, maybe you registered your company's name with the California's Secretary of State to do business in California. Now, that's not necessarily a trademark. It could be if you start doing business with that registered name, but it doesn't automatically become a trademark just by registering that name to Secretary of State. All right, we went through a lot already. Any questions so far? I know I'm going a little fast, sorry.
Well, I know that was really helpful with the trademarks, and it brought up a question I know I've seen with a farmer in the past, but also a clarifying question on trade secrets. One person was just clarifying, like ingredients and nutritional information is legally required for, food products like Coca-Cola or KFC. But it's what just confirming a trade secret is the recipe itself. So you can't find like Coca-Cola's recipe anywhere, right?
That's correct. That's correct. So um, now, like nutritional information, all that's like FDA required, or if you're developing a new pharmaceutical drug, there's definitely other regulatory authorities that might, be affected here. But in regards to a trade secret itself, it really is the recipe itself. It doesn't have anything to do with safety concerns or anything else like that. So yeah, it's even like for when I discuss patents, when this next section, we're going to discuss quickly composition of matter as being part of patent eligible. So basically, pharmaceutical drugs or some other composition. Um, and they sometimes they do get involved with different regulatory authorities in conjunction with the patent, but it's not one or they're fairly separate things, processes.
Yeah, and I'm thinking of how it would apply to some of our farmers that we work with. Like, let's say a farmer grows tomatoes and they've created a value added product that's their own farm tomato sauce. And let's say this sauce really takes off and like people want to purchase it, distribute it for them. So they're gonna, disclose the what ingredients that is in there, but like what makes their sauce so perfect. It's maybe like they did a certain temperature, or maybe they like fermented something
Yeah,
first. And so that if it really like takes off, they would maybe want to consider getting a trade secret for that recipe so that it can't be stolen, or is that like an example of maybe how that would work out?
absolutely. So it's you're not getting a trade secret, right? It's just that you're identified something that you own, your proprietary,
Yeah.
wow, fuzzy head. Sorry.
End of the day,
Uh,
yeah.
Information where you deem it like I don't want anyone else to know. I'm just going to try to keep this as secret as long as I can.
Hmm.
So maybe your recipe goes into a vault and only one person in your company knows the how to access it, right? That kind of idea. Um, so it's really up to you to identify what intellectual property you might want to protect.
Hmm.
And with that said, like if you even once you get that intellectual property, will you enforce it? What are you going to do with that intellectual property? Are you going to just keep it in the vault? Are you going to maybe use it as an asset to get collateral loans, as collateral for a loan? Right? You
Gotcha.
potentially can do that because, like any asset, it really depends on how much value is in that asset.
Hmm. Yeah, that's helpful. Okay, thank you. And I'll know, I think I know we don't have too much time left, so I'll keep
Oh,
the
sorry.
trademark. No, I know. I just the trademark is really interesting because I think a lot of farmers with their domain names and having their businesses registered, having their brand, but I don't know if, trademarks are fully understood with how that can be applied or if it needs to be applied. Um, so we can maybe keep moving and see if we have time at the end.
Okay, and that's a really good point. Like for most business owners, um, the most applicable intellectual property is trademarks.
Mhm. Right. That's yeah, it makes sense for them too. Okay, thank you. And then Kurt did have a follow-up question. So he's just confirming a trade secret has nothing to do with federal registration at any level. It's like your company owns it and you can use it to your advantage to get capital, maybe additional financing or get more
Exactly.
buyers because they can't mimic your recipe. That's
Exactly.
okay. So it
Exactly.
has
There's
nothing.
no government agency that you would use to register a trade secret.
Right. And maybe for in court too, if something tries to get stolen by a previous employer or something, I guess that you maybe have some power there too.
That is correct. So it wasn't only until recently that there's a federal law in the books that now allows you to go after misappropriations of trade secrets in federal court. Before that, a lot of the trade secret type of infringement was done in like labor law because it was usually an employee taking the secret to another company type
Okay.
of labor law. Okay.
Interesting. All right. Well, we'll let you continue. I know we don't have too much time left, but
Yeah, I'm sorry. I'm gonna zip through here and hopefully I'll be able to answer some questions.
and if people have
So
questions on trademarks, please put those in the chat and we'll get to them.
or patents, and I'll try to get to them afterwards or after this session as well. So U.S. patents. So this is the final form of the four that I described of intellectual property recognized in the United States. Now, most people know these as inventions. That's the majority of the types of patent applications that we examine are utility patents. All of them have very similar types of rights here. They exclude others from making and using and all that jazz for a limited time in exchange that the public will eventually know about these and be able to use them and improve upon them later. So three types of patents: utility, design, and plant. I know there was already a question about plants. Um, Utility by far the most common of the patents. Roughly 20 years from filing date is your term of protection. And they're machines, inventions, composition of matter I mentioned before, like if you think about a pharmaceutical drug or maybe a vitamin or even the composition of like a new material, like Gorilla Glass. I don't know what that composition is or something. Articles of manufacturing, basically like a simple device, machines, processes. Processes could be like how you actually do something that might be novel, right? So designs are very interesting. These are ornamental features of um, article of manufacture. So they're only for 15 years. The automobile industry uses design patents all the time because what they want to do is protect, say, Ford company wants to just put out the 2026 Ford Mustang. Well, they redesigned a few things on the Ford Mustang. Now they want to protect the look of some of these components, say the new fender or the new hood or something, so that they use design patents so that third-party manufacturers can't um, create replacement parts to these same designs with these same designs for the Ford Mustang. So automobile companies use these all the time. Plant patents, very interesting, very small niche of the patent system. Now, you can't patent anything just naturally grown in nature, but if you discover or invent something new and distinctive and can asexually reproduce it, such as from cultures, you can possibly get a plant patent on it. I actually kind of described all of these. So what is eligible? Let's continue. What is not eligible? Laws of nature, physical phenomena, abstract ideas. One of the things that when you submit a patent application is you basically have to describe how someone later reading your patent application or patent can reproduce it. So it can't be an abstract idea. It has to be very detailed. Patentability for the most of these, especially utility patents, they have to be new, useful, and non-obvious. Um, New is common in intellectual property. And why is new such a big thing? Because in the United States, well, any patent basically, in order for you to get a patent, it has to be new, not just in the United States, but anywhere in the world. So before you submit a patent application on your new invention, you should just do some searches on our database of US patents, but also other patent databases around the world. You should do Google searches or whatever your favorite search engine is and start doing searches on your invention, making sure that it hasn't been done anywhere else, even in research publications or articles or things of that nature. Now, you also have I don't think I have a lot of time here, but you also should be careful about how you tell others about your invention before you submitted a patent application. Because if you disclose it, say if you go to a trade show and disclose exactly your new invention to possibly an eventual buyer or investor, well, you just made a disclosure, a public disclosure. Now, in the United States, you have a 1 year grace period. Most other countries don't have that. So even if you disclosed your own invention, you have 1 year where you have to submit a patent application to our agency, um, or it's no longer considered new, even if it's your own disclosure, your own invention. If you waited over a year, it's no longer considered new. Now, other countries might not have a year grace period, so be careful of that. If you're thinking of, um, getting a patent from Japan, I think there are 6 months grace period. So if you put your invention out in like a research journal or went to a convention and asked an investor, oh, this is how it's done. Will you invest money in my company? Well, if it was more than 6 months, then you can't get a Japanese patent. So just be careful of that. Disclosures. And there's more information on our USPTO.gov website as well. Really quickly, just for patents. So I mentioned we are a fee-funded agency. So everything basically you do with our agency, you submit an application, you have to pay an application fee. Um, you do certain things with your application, you have to pay more fees. So we do have three-tiered system for patent fees. The first is a standard fee. Small entity is basically 60% discount on all our patent fees. And it basically is like if you are a small business, you probably could fit in the small entity status. Micro entity is very small. Micro entity is basically for independent inventors that have don't have a lot of experience submitting applications before. So there's actually a requirement on how many times they've actually submitted applications. But if you fit as a micro entity, you get 80% discount on the patent fees. So just be aware of that.
That's awesome. That's probably most people we work with.
Yeah, yeah, probably. Now, of course, we understand the patent application system is very difficult process. We always recommend that a patent applicant use legal representation, like a patent attorney or a patent agent. Now, of course, you might not be able to afford it because when you talk about patent, how much does it cost to get a patent? It's usually those legal fees that are just blowing up. So it's always a good idea to try to educate yourself first to see if you really should be getting a patent or any other form of intellectual property, but especially a patent, if it's worthwhile. What do you plan on doing with it? Um, will you get legal representation, right? The more you educate yourself, the better, or the um, the less interaction you have to have with your attorney or patent agent, and fewer legal fees, right? That's one of the benefits. They don't have to sit there and explain to you what a patent is, or I don't know, $1,200 an hour on legal fees, right? But also, if you go to our website, uspto.gov free services, you can see a whole list of free resources and services that we provide to the public. Um, and also, we have an IP identifier that is basically an online survey that asks you some questions. If you don't know exactly what type of intellectual property you might have or might own, well, this can help identify you and also identify the intellectual property, but also provide some references for you to look at. We also have hotlines at our USPTO. So these go to our headquarters, but we have one for patents. It's called the Inventor Assistance Center. And we also have a similar one for trademarks, the Trademark Assistance Center. And then we have we work with a number of libraries around the nation that also have librarians that we have trained or helped train to do searches and provide resources to people. I don't think this map is actually updated, but you go to our website, you can see those PTRCs, Patent and Trademark Resource Centers. As I mentioned, I can't provide legal advice. No one in our agency can provide legal advice, but we have partnered with nonprofit attorney organizations that do provide legal assistance for free. They're called patent pro bono programs. Go to our website here. You can see who is listed as a patent pro bono program member, and you can see if you qualify for their services. Now, this isn't an exclusive list. Other organizations have their own pro bono type programs. So you might also want to see whatever's around you locally. Law school clinic programs, very similar. We work with different law schools that have clinics where they allow their law students to get to help draft applications for clients under the supervision of their professor or a attorney. Um, Now, keep in mind, these are law school students who are still learning the law. So it's kind of like going to Supercuts, right? Stop Fakes is an interagency effort to just help provide resources about combating counterfeits and things of that nature in the marketplace. So, but I think that's about it. Thank you very much. I know I went very quickly during those last few slides, but any questions?
Well, thank you so much, Ken. And yeah, if folks have questions, please feel free to put it in the chat or chime in. But yeah, I always feel like there's so much to learn about this topic, and I was pleasantly surprised to learn about all the resources for free that your office and like have partnered with our local librarians, for example. I had no idea that those resources were available. So that's a huge support to our small farm businesses who I think qualify for most of those services
Yeah,
you
absolutely.
mentioned.
And
Uh,
also, I would recommend if maybe connecting with the Small Business Administration, SBA, they support a lot of small business organizations around the country. But if you're in the Valley, um, you know, there's the Fresno SBA district office supports multiple SBDCs, small business development centers. Many of them are run out of the local universities, but you can find them other places as well.
mhm.
Look up their services. They have a wealth of knowledge supporting small businesses. So that business strategy advice that we can't provide, they might be able to.
That's great to learn. And yeah, I know I feel like there's going to be questions more on trademarks too, but I'm assuming the
Yeah.
website has more information on the trademarks and like factors to consider.
Yes, absolutely. Again, we can't provide business strategy advice, but we do try to list a few things about just considerations. I know just a fun little thing, the Haas avocado, and it's actually spelled HASS. Many of you probably already know that plant patent originally.
Mhm. Wow.
Um, and this is our main website, uspto.gov, www.uspto.gov. And if you want to get to the resources, you could just access this. Um, and if you are curious about our fees, you can go to Find It Fast and Fees and Payments here.
Great. Yeah, and that's great to know too, because I know, for example, I believe like some filing fees are 300 and something dollars, but then I hear people saying like, "Oh, I spent $10,000 on my patent," and then those are the legal fees, like you were saying. So, it's helpful to understand how those prices add up.
Exactly.
Yeah.
Exactly.
Well, we appreciate. I know we're already past time a tiny bit here, so we'll wrap things up. But if anyone has any questions, feel free to reach out. Ken, I know you shared your contact information, but would folks be able to contact you if they wanted?
Absolutely, absolutely. Again, there's certain things, limitations on what I can say, but maybe I could refer you to certain people.
Great. Thank you for that. And yeah, just one final disclosure because this will be recorded and posted to our website, but it is May 6th, 2025. And so if this is 3 months from that date, 6 months from this date when you watch it, things may be outdated, prices maybe have changed, community resources maybe have changed. So please just be mindful of that if you're watching this video too far into the future. So yeah, thank you, Ken, so much for presenting to us and taking the time. And we appreciate folks for joining. And yeah, stay in touch with the Tech Hub. Let us know what additional resources may be helpful for you, and we'll get something organized.
Thanks for putting this together, Elizabeth.
Oh, thank you, Kurt. Yeah, I appreciate it.